The Subcommittee on Water Resources and Environment will come to order. I ask unanimous consent that the chairman be authorized to declare a recess at any time during today's hearing. Without objection, so ordered. I also ask unanimous consent that members not on the subcommittee be permitted to sit with the subcommittee at today's hearing and ask questions. Without objection, so ordered. As a reminder, if members wish to insert a document into the record, please also email that document to, listen up, documentsti@mail.house.gov. Again, documentsti@mail.house.gov. I now recognize myself for the purposes of an opening statement for 5 minutes. For just over half a century, the Clean Water Act has functioned to improve the quality of rivers, lakes, and streams throughout the country. Congress recognized that we had a major issue with the quality of our nation's waters and understood the many benefits that are derived from access to clean, navigable waters. North Carolina's 7th Congressional District, which I'm honored to represent, is known for its beautiful waterways and beaches that provide significant recreational and economic benefits. We also have many important bodies of water that we rely on for commerce and drinking water. The Clean Water Act has had great success in its 50 years protecting waters in North Carolina and all around the country. We should be proud of the progress we have made to restore and maintain the chemical, physical, and biological integrity of the nation's waters. And it is important that we not ignore innovation and other major changes that have occurred since Congress passed the Clean Water Act back in 1972. Now, more than 50 years following its enactment, it is not only appropriate but necessary to reflect on how the Clean Water Act works and what parts of it might need an update. There is no better to start that review than right here in this subcommittee. Now, as we all know, the United States frequently scores poorly on infrastructure reports. We are being outmaneuvered by our competitors worldwide, China in particular. Now, we certainly all agree that there should be rules of the road. But as I like to say, we don't need a stoplight every 10 feet like we have, literally, here in Washington, D.C., on some streets in particular. Regulations should be simple to understand and easy to follow, which coincidentally makes them so much easier to enforce. Our worldwide competitors care little to nothing about any regulatory structure or permitting. When they want to do something, they just go do it. Now, we are better than that, of course, and we should be. But it doesn't mean we should be forced to accept a timeline of years to build a manufacturing plant or to build a wastewater treatment plant or energy project. All this does is give our international competitors a distinct and significant advantage. Now, regulations should carry out the intent of the law transparently and not leave regulated communities, whether it be miners, utility companies, state and local governments, manufacturers, or any other hardworking American, subject to bureaucratic uncertainty or to line the pockets of trial lawyers. American innovation, greatness, and competitiveness cannot be achieved when the country is stuck in a bureaucratic quagmire. Today, the subcommittee will hear perspectives on how the Clean Water Act can be modernized so that its rules and regulations fit the current times while still accomplishing the goal of making waters of the United States fishable and swimmable, ensuring the completion of important infrastructure and energy development projects for things like wastewater management, the mining of critical minerals, and water resources development is vital to reducing supply chain challenges and promoting commerce. In doing so, we can reassert American strength and compete worldwide while protecting the quality of our water all at the same time. Now, this hearing is the latest action we are taking to examine and modernize the Clean Water Act. This morning, we have a knowledgeable panel of witnesses representing a diverse array of interests who are all affected by the Clean Water Act, including wastewater agencies, manufacturers, and state governments. This panel of stakeholders is well versed on the details of Clean Water Act regulations, and our focus today is on two of the main regulatory provisions of the CWA. Section 402, the National Pollutant Discharge Elimination System Program, and Section 404, the Dredge and Fill Material Discharge Program. Now, I'm eager to hear from our witnesses about their experiences with the CWA regulations and their ideas on how to improve and update it for the benefit of everyone. In particular, I look forward to hearing their comments on the NPDES program, including the creation of guidelines on effluent limitations, Section 404 issues such as nationwide permits, and any other insights into the CWA programs they may have, especially as it relates to responsibly advancing energy and infrastructure project completion. I ask unanimous consent to enter into the record a statement for the record for today's hearing by the National Mining Association dated May 16, 2023. Without objection, so ordered. I also ask unanimous consent to enter into the record 2 letters, one from the American Petroleum Institute dated May 15, 2023, sent to Ranking Member Napolitano and myself, and one by the National Stone, Sand, and Gravel Association dated May 15, 2023, also sent to Ranking Member Napolitano and myself. Without objection, so ordered. I now recognize my good friend and colleague from California, Ranking Member Napolitano, for 5 minutes for an opening statement.
Thank you, Mr. Chairman. You have continued the subcommittee's long history of success in addressing the bipartisan water resources needs of our nation, as clean water is essential to our livelihoods, our health, our environment, and our businesses. The strength of the American economy is reliant on a clean water supply, as it is key ingredient for manufacturing, farming, food processing, small business development, tourism, recreational businesses, and businesses. If we do not protect our nation's water, this will have a negative impact on business, as they will not have high-quality water they need for the production and growth. The decline of water requirements will require consumers, businesses, residents to pay more in water utility bills to treat the water before it comes to the tap. And I agree with you, we should not be competing with China because we will have to lower our standards, and I don't want that. This is true whether you live in a coast or in the middle of the same country, whether you live in a big city or a small town, or whether you live in an affluent community or a community struggling to make ends meet. Over the past 50 years, the Clean Water Act has made considerable progress in addressing our nation's water quality concerns. Through a substantial investment of resources spurred by federal dollars from the Clean Water Act, this nation was able to fundamentally address the discharge of raw or partially treated sewage into our rivers, streams, and lakes. However, challenges remain. Over the last decade, communities and states have called for additional federal dollars and resources to address lingering high-quality concerns. In response, last Congress, House Democrats delivered with enactment of the largest investment in wastewater infrastructure in generations through the bipartisan infrastructure law known as BILL. Over the last 5 years, covered in BILL, this critical legislation will provide approximately $13.8 billion in federal clean water resources to address the many local water quality challenges. Further, in recognition that not all communities are on equal financial footing, the bill ensured that roughly half of the funding would be provided in form of grants or other flexible financing to address the needs of economically disadvantaged communities, including rural and tribal communities, many of which had borne the burden of environmental contamination for far too long. Yet, as important as robust water infrastructure financing might be, there are limits of what can be done relying solely on wastewater infrastructure investment. Over the past few years, more and more communities have experiencing recurrent outbreaks of harmful algal blooms that can produce toxins, kill fish, mammals, birds, contaminate drinking water resources, and cause human illness or even death in extreme cases. And then we have a new contaminant coming up, it's PFAS. We've got to look out for that. As shown on the maps on the screen, if you look at the screen, harmful algal blooms have become a national concern because they affect not only the health of people and marine ecosystems, but also the health of our economy, especially coastal communities dependent on the income of jobs generated through fishing and tourism. We all know that a major cause of these blooms is excessive nutrients, such as nitrogen and phosphorus, in the U.S. waters. Unfortunately, according to state data, excessive nutrients continue to be one of the nation's leading water quality issues. Today, approximately 58% of the rivers and streams, 40% of the lakes, 21% of coastal waters are impaired due to high levels of nutrients. You see the location of many of these contaminated waters on the map, second map on the screen. Mr. Chair, I ask unanimous consent, both maps be made part of today's hearing record.
So ordered.
What is worse than that, according to EPA, the percentage of nutrient-impaired water waste is increasing, even with substantial investment in our nation's infrastructure, in wastewater infrastructure. And we need to do more. Very clearly, we need to do more. Unfortunately, in my opinion, every water bill advanced by this committee in Congress would needlessly weaken federal and state efforts to protect our waters from pollution, such as excessive nutrients. In my opinion, every water bill advanced in this Congress would result in more water bodies being impaired by contamination, such as harmful algal blooms, not less. Now is not the time to pull back on federal investments on wastewater infrastructure. Now is not the time to weaken the federal and state efforts to protect our nation's water and our country's water. Now is not the time to weaken a clean water future. We cannot regress. I welcome our panelists here today and look forward to valued input. And I would like to have unanimous consent that a letter from the National Wildlife Federation dated May 16, 2023 be included in today's part of the hearing.
Without objection.
I yield back the balance of my time.
The gentlelady yields. I now recognize the ranking member of the full committee, Mr. Larson, for 5 minutes for an opening statement.
Thank you, Mr. Chair. So my state is defined by its clean water. From the Puget Sound to the hundreds of lakes and thousands of miles of rivers and streams throughout Washington. Washingtonians know that protecting these rivers, streams, and wetlands takes work and attention, and that the health of one body of water is intrinsically connected to the health of another. Our waters and water-related economy depend upon the protections of the Clean Water Act and its pollution prevention programs. It is more effective and less costly to prevent pollution than to clean up pollution. That's true in my state. It's true in every state and territory. The Puget Sound has several programs and authorities dedicated to its recovery, but even with these investments, progress remains slow. Improved water quality is a foundation of recovery and is essential to other goals like habitat restoration, increasing species population, and improving the resiliency of the Sound. So when this committee passed the Clean Water Act over 50 years ago, members recognized the effectiveness and importance of comprehensive pollution prevention measures rather than simply investing in pollution cleanups. In passing the CWA, Congress specifically noted that the state-by-state, go-it-alone approach was, quote, inadequate in every vital aspect, end quote, and left waters severely polluted and expensive to restore. So for decades, Republicans and Democrats shared these bipartisan principles to achieve clean water, to maintain a strong federal-state partnership to protect our waters, to stop pollution from entering the system in the first place, and to support a robust federal floor of protections while allowing states to do more but not less. And last Congress, we passed the bipartisan infrastructure law, affirming our commitment to improving our infrastructure. The BIL included significant investment in our water infrastructure, providing $13.8 billion in federal dollars for upgrading our wastewater systems, preventing pollution discharges, and supporting restoration programs in places like the Puget Sound, but many other places as well. These investments are critical, providing a lifeline to communities across the country struggling to maintain water quality. And members who voted for BIL voted for clean water. And such a large federal investment requires careful oversight to ensure congressional intent is met. On that, we have agreement. Communities are best served if agencies get the program set up and get those funds out the door quickly. On that, we also have agreement. Where we diverge, however, is using these investments sometimes as an excuse to weaken the Clean Water Act under the guise of expediting projects. We'll hear testimony today about how project delivery reforms that may sound good can have an adverse impact on water quality. Clean Water Act investments have led to significant progress in restoring the chemical, physical, and biological integrity of our waters. Still, a lot of work remains to be done. EPA data indicates that the percentage of impaired waters is back on the rise. Impaired waters are those that do not meet water quality standards, and today, a leading cause of impairment is excess nutrients. I think almost everyone on this committee has water bodies in their district that are threatened by harmful algal blooms and other algal growth fueled by excessive nutrients. As we saw on the map from NOAA, there are harmful algal blooms outbreaks across the country. Florida, the Chesapeake Bay, the Great Lakes, and of course, in the Pacific Northwest, we all have significant outbreaks. Virtually no region is untouched. So I can't support weakening clean water protections and increasing the chance of excess nutrients and pollution entering water systems. So I urge my colleagues representing affected regions on this map to think through what weaker protections means for constituents. This is just one example of a growing water quality problem. Removing or weakening protections now will cost more in the future, even without other factors making the situation worse. Yet we know that climate change threatens our water supply, water quality, and water ecosystems. So other factors will come into play. So now is not the time to retreat on the goals and intent of the Clean Water Act. I encourage ideas to get the bipartisan infrastructure law funding to our communities faster, but ideas that put polluters over people and saddle the public with the cost of cleanup are not sustainable. I thank the witnesses for joining us today, and I look forward to your testimony. With that, I yield back.
The gentleman yields back. I'd now like to introduce our witnesses and thank them for being here today. First is Dr. Andrea Travnick, Director of the Department of Water Resources, State of South Dakota. North Dakota, pardon me. I had Dusty Johnson on my mind. My apologies. The Honorable Serena Coleman McElwain, Secretary of the Environment, State of Maryland. Mr. Mickey Conway, Chief Executive Officer of Metro Water Recovery in Denver, Colorado, and is here on behalf of the National Association of Clean Water Agencies. And Mr. Brandon Ferris, Vice President for Energy and Resources Policy, National Association of Manufacturers. Now, briefly, and you all know this, but I want to take a moment to explain the lighting system to the witnesses. There are 3 lights in front of you. Green, obviously, is go. Yellow means your time is running short. And then, of course, red means that it's time to wrap it up just as quickly as you can. I ask unanimous consent that the witnesses' full statements be included in the record. Without objection, so ordered. As your written testimony has been made part of the record, the subcommittee asks that you limit your oral remarks to 5 minutes. With that, Dr. Travnick, you are recognized for your 5 minutes.
Good morning, Chairman Rouser, Ranking Member Napolitano, and members of the subcommittee. Thank you for the invitation to testify today on the impact of the Clean Water Act on infrastructure project completion. My name is Andrea Travnick, and I am the Director of the North Dakota Department of Water Resources. The department is charged with managing the use of the state's waters. In managing North Dakota's waters, the department works closely with other state agencies. We understand North Dakota's unique hydrological landscape. North Dakota has over 1 million wetlands, covering approximately 6% of the entire state. Many of these wetlands are in North Dakota's prairie pothole region and may be isolated and temporary. North Dakota diligently protects these wetlands in all its waters, both surface and subsurface, while at the same time encouraging appropriate economic development for beneficial use by agriculture, oil and gas, and other industries. We take these management responsibilities very seriously and strongly believe that North Dakota's waters are better protected and more effectively managed by North Dakota agencies than by federal agencies headquartered in Washington, D.C. Over the past decade, North Dakota has vigorously resisted federal intrusion into the management of its state's waters, including the EPA's and Corps' latest rule defining waters of the United States, or WOTUS, for purposes of the Clean Water Act. Currently, North Dakota and 23 other states are challenging the rule in a lawsuit brought in North Dakota Federal District Court. Recognizing the rule's harmful impacts, Judge Hovland issued a preliminary injunction order that prohibits application of the rule in the plaintiff states. As a result, the pre-2015 regulatory regime remains in place in North Dakota. If the new WOTUS rule went into effect in North Dakota, the department would be directly impacted because it manages numerous large water infrastructure projects and assists with flood control and water supply projects throughout the state. With these projects, the department is often in the position of applying for dredge and fill permits from the Corps under Section 404 of the Clean Water Act. Under the rule, the department would be forced to undertake an expensive jurisdictional analysis for these projects to determine if they impact WOTUS under the expanded definition and are thus subject to Section 404 permitting requirements. For example, the Northwest Area Water Supply, or NAWS, which is owned by the state of North Dakota, intends to bring water to 81,000 North Dakota citizens in the north central prairie pothole region of our state, with a greatly improved water supply, both in terms of quality and quantity. Many cities and rural areas in the NAWS project area have domestic water supplies that do not meet minimum drinking water standards. The benefits of NAWS include not only a clean and abundant water supply of water for the residents of North Dakota, but more opportunities for potential industries and a stronger economy. To date, federal, state, and local partners have already invested over $350 million into NAS projects, with an additional $85 million in water investments planned. The risk of NAS infrastructure being potentially adversely impacted by this rule is unthinkable and could have tremendous human health and economic impacts to the state. Intrusive federal regulation may have unintended consequences that are harmful to the environment. The new WOTUS rule would also result in additional costly evaluations to determine Section 404 permitting requirements for other underground pipelines being built in the state as well. Pipelines may need to be rerouted with excessive re-engineering costs, permitting delays, or perhaps canceled altogether. This could impact pipelines needed to transport natural gas, to reduce flaring, and meet the state's target of reaching 98 to 100% gas capture and 0% routine flaring by 2030. To meet this target of eliminating flaring, the gas gathering and processing industry needs to construct thousands of miles of natural gas pipelines per year for the next 10 to 15 years. The rule would also impact the ability to construct the thousands of miles of pipelines needed to transport carbon dioxide to meet national carbon capture and storage goals. Even without the new rule, Section 404 permitting requirements cause harmful delays that could lead to cost increases, especially in North Dakota's prairie pothole region, where it is often subjective as to whether WOTUS will be impacted. Section 404 permitting delays are also especially harmful in North Dakota due to our short construction season. A loss of one construction season carries through the entire infrastructure program, resulting in cumulative increased trucking and the associated environmental impacts to air quality, as well as increases in costs. In addition to rescinding the new WOTUS rule, one solution to ease overly stringent federal permitting requirements would be to adopt state-specific regional conditions for the core nationwide Permit 12, which applies to oil and gas pipelines, and nationwide Permit 58, which applies to any linear utility line. State regional conditions should be adopted into these nationwide permits to address federal and state environmental concerns, as we proposed to the Corps as recently as October 2020. Another area for improvement would be to have more consistent application of Section 404 permitting requirements by Corps staff, and to address staffing issues at the agency that exacerbate permitting delays. North Dakota has a significant interest both in the proper management and protection of its state's waters and in improving its infrastructure to support public health, safety, and the economy. We appreciate the partnership of the federal agencies in achieving these goals, but our federal partners must respect states' rights. The EPA and the Corps should work with states to reduce uncertainties and inconsistencies in Section 404 permitting and other Clean Water Act programs to improve the ability of states to timely complete important infrastructure projects.
Thank the gentlelady. Secretary McElwain,
Thank you.
you have 5 minutes.
Okay, thank you. Can you hear me? Okay. Good morning, Chairman Rouser, Ranking Member Napolitano, Chairman Graves, Ranking Member Larson, and the members of the subcommittee. Thank you for inviting me here today to testify on the importance of the Federal Clean Water
If you can
Act.
bring that microphone just a little closer to you, I think that would.
How about now? Is this better? All right, move up a little bit. Okay. To the nation's health, economy, and overall quality of life. Just over 50 years ago, Congress passed the Clean Water Act, and I want to start by reflecting on the history that led to the passage. In the late 1960s, rivers were literally catching on fire from oil and industrial pollution discharges. A 1969 Time magazine article published dramatic photos of fires on the Cuyahoga River in Ohio and described a river that oozes rather than flows. And I'm attaching one of those photos for the record, and you can see that here. At the same time, Rachel Carson's famous book, Silent Spring, revealed the hazards of pesticides and a historic oil well blowout off the coast of Santa Barbara, California, which galvanized the public and Congress to take action to protect our waters. As a result, President Nixon created the Federal Environmental Protection Agency in 1970, and Congress passed the Clean Water Act in 1972. One of the central goals of the Clean Water Act is to ensure that the nation's waters are fishable and swimmable. And that means that our waters are safe for our children to swim in, and that we can safely consume fish and seafood from our waters without fear of getting cancer or being exposed to toxic substances. The Clean Water Act also helps to protect drinking water sources from contamination. The Clean Water Act does this by establishing designated uses, for example, as a public water supply, for the nation's regulated waters, setting science-based criteria and standards that will meet those uses, and by ensuring that waters meeting their uses are not degraded by pollution. The Act also allows for standards to be set using either water quality or best available technology standards. And while we have made progress over the years, our waters are no longer catching on fire. There is still so much work to do to ensure all the nation's waters are fishable and swimmable. At the same time, we have emerging contaminants to deal with, like PFAS, and they are contaminating our drinking water and fisheries. In fact, according to EPA's own data, only 30% of our rivers and streams are healthy. 40% of our nation's lakes have excess nutrients that help fuel algae blooms. Only 71% of our estuaries and 31% of our Great Lakes and nearshore environments have healthy aquatic communities, and only 48% of our national wetlands have healthy biology. If we're giving ourselves a report card, 4 out of 5 of those statistics represents we are failing. I come from Maryland. The amazing Chesapeake Bay and its watershed run through the heart of our state. And the Chesapeake Bay and its tributaries do not just belong to Marylanders. These waters are a part of our national identity and heritage. The overall health of the Chesapeake Bay and its tributaries has dramatically improved as a result of mandates under the Clean Water Act. From leadership by Maryland's government over the past 50 years, significant federal, state, and local investments, and the commitments and actions by local governments. A healthy bay is vital to protect vulnerable people from climate change, strengthen our shorelines to buffer against waves and storm surges, and support healthy ecosystems and fisheries such as our rockfish, oyster, and crab population. Since 1985, Maryland has reduced its nitrogen pollution by about 40%, or about 35 million pounds per year. Data collected confirms that water quality in Maryland is trending in the right direction. One of our largest reductions in pollution comes from wastewater treatment plants, which are regulated under state and federal Clean Water Act permits. A total of 67 of the largest and many of the smaller facilities that treat sewage in Maryland are now operating using cutting-edge technology. The water is cleaner and able to be reused. These environmental successes put Maryland in a national and international leadership position that all began with the Clean Water Act. Additionally, more than 90% of urban runoff in Maryland falls under the protection of the Clean Water Act. This means by better managing stormwater runoff, we are making our communities more spongy, soaking in rain, and so more resilient to storm events, and reducing pollution and flooding. In the next 5 years, new permits will add another 11,000 acres to the 35,000 impervious acres restored under prior permits. The restoration is larger than the area of Washington, D.C., and results from bipartisan environmental leadership spanning multiple administrations. These permits drive climate resiliency, green infrastructure, and advance innovations such as pay-for-success contracting, public-private partnerships, and new technologies.
I thank the gentlelady for her testimony. Mr. Conway.
Good morning, and thank you, Chairman Graves and Rouser, Ranking Members Larson and Napolitano, and all the members of the subcommittee for the opportunity to testify today. I'm here on behalf of the National Association of Clean Water Agencies, or NACWA, to talk about potential improvements to the Clean Water Act. My name is Mickey Conway. I'm the CEO of Metro Water Recovery. We're a clean water treatment and resource recovery facility in Denver, Colorado, serving 2.2 million people. It's about 40% of Colorado's population. And I'm also privileged to serve on NACWA's board of directors and honored to represent its over 350 public clean water utility members that, like Metro, are anchor institutions in protecting public health and the environment. This is what we do every day, and we're proud to be here to talk about that. Clean water utilities today face unprecedented challenges, including aging infrastructure, climate resiliency issues, managing nutrients and emerging contaminants such as PFAS. And those are things that our folks dive into with vigor every day. But additionally, and just as important to managing those issues, is managing them in a way that keeps our ratepayers in a place that they can pay their bills. Many of the folks who in our service areas are having trouble paying their rent, they're having trouble paying their grocery bills, and much less their utility bills, and all of our investments have to make sense for them and actually improve water quality. And that really especially pertains to those in small, rural, and economically disadvantaged communities. So with all that in mind, there are 3 key Clean Water Act improvements I'd like to discuss briefly that will, I think, provide 1, regulatory certainty, and 2, making sure dollars are going towards clean water and not towards litigation or changing course and really affecting our ratepayers disproportionately. These all involve our NIPD's permits. So members like NACWA members operate pursuant to permits issued by the National Pollution Discharge Elimination System, or NIPD's. And these permits basically tell us what we can put into the waters. They also guide us in our infrastructure projects to make sure we can meet the permits. And these projects, as you can imagine, are incredibly complex. They're very long in term, and changing the rules in the middle of the project is like turning the Titanic around. You just can't do it. And so for us to, in order to be able to deliver clean water at a reasonable price, we've got to be able to rely on permit terms and rely on the permit system throughout the term of the permit. I guarantee that any public servant in front of you will tell you that you better have a plan before you dig up city streets and spend billions of dollars in infrastructure, and that permit is our plan. So Clean Water Act Section 402 has a permit shield provision, which is expressed in EPA policy at this point, and the permit shield is essentially laid out like this. If the permittee provides all the necessary information to the permit writer incorporates that information and includes the necessary limits in the permit. And then at that point, the permittee can rely on that permit. Whether or not pollutants are expressly laid out in the permit or not, whatever is discharged is considered lawful. The United States Supreme Court expressed that that was all, the entire permit policy is really to express finality of the permit, and that's what utilities can rely on. That finality is being challenged now in a number of litigations, and the methodology of challenging is the scope of the permit shield is that we're going after pollutants that are not expressly laid out in a NIPD's permit. The problem with that, an example is PFAS. PFAS is not in wastewater permits at this point and will not be for many years. If people can sue utilities over discharging PFAS, which we as wastewater utilities just passively receive, the money that our folks who are having a hard time paying bills for is going to go to litigation, and it's not going to go to cleaning up the water. We're working very hard to manage PFAS, but we can't also fend off lawsuits for something we can't control or we're not permitted for. The second scope of 402K that we're looking to get improvements on is language in the permits themselves that is ambiguous and invites litigation. There are boilerplate languages added to certain permits that say discharges shall not cause or contribute to the violation of water quality standards. I've been in this business for over a quarter century. I have no idea what that means. I need to have limits that I can hit with constituents that I can hit, and not limits that are not language that invites litigation and, again, transfers money from my ratepayers into lawyers' pockets. And I'm a former practicing lawyer, so I will say that I think there's plenty of opportunities for attorneys to make money elsewhere. Finally, I think we would like to just note that the objectives of the Clean Water Act would be better served if water quality standards are done in a more transparent way. We'd ask that EPA undergo notice and comment rulemaking when developing standards and provide for limited judicial review. That allows communities to reflect and participate in the process and talk about what meaningful standards will be, especially since the burden of cost on those communities falls to take care of that. So I think these 3 potential improvements would help with regulatory certainty and, again, putting the money where it needs to go in the Clean Water Act towards clean water projects. Thank you for your time.
Thank the gentleman. Mr. Ferris, you have 5 minutes.
Good morning. Good morning, Chairman Rouser, Ranking Member Napolitano, members of the committee. Thank you for the chance to speak with you on behalf of the 13 million men and women who make things in America to convey the urgency of permitting reform. Streamlining and modernizing our nation's permitting laws and procedures will help us advance many of our nation's shared priorities, improving the quality of life for all communities, modernizing our infrastructure, achieving energy security, ramping up critical mineral protection, enhancing manufacturing competitiveness, and creating manufacturing jobs in the U.S. These are goals that all Americans can support. At a time of economic uncertainty, when every investment in a new power plant, a new road, a new manufacturing facility makes us more globally competitive, why should we settle for a permitting process that can take 10 or 15 years to approve essential projects? One of manufacturers' biggest concerns is that the permitting process often drags far longer than necessary. For example, here's something we've heard from one of our manufacturers of critical raw materials for semiconductors, clean hydrogen, and lithium-ion batteries. In many cases, these products cannot be made without their chemicals, but because of the regulatory uncertainty in obtaining a Clean Water Act Section 402 permit in a timely manner, that company recently announced that they're going to build a facility in the EU that manufactures material necessary to produce clean hydrogen. A White House CEQ report also found that environmental impact statements, mandated under NEPA, take on average 4.5 years. That means more time is spent projecting potential environmental impacts than it takes to actually construct and operate a hydrogen power generation facility. The impact of leaving our existing permitting processes untouched is clear. The U.S. will fall behind international competitors that are taking every step possible to incentivize manufacturing development. Quality of life, environmental progress, and economic competitiveness in the U.S. will suffer as a result. Permitting reform can be achieved without compromising our nation's or our industry's high standards for environmental protection and sustainability. It is possible to preserve and uphold these standards, but with fewer delays and fewer needless lawsuits. So as detailed in my written testimony, manufacturers have a few priorities. First, we want to see consolidated processes with enforceable deadlines for the siting of new energy projects, including hydrogen, natural gas, nuclear, and other emerging technologies and their infrastructure. Second, we want to see faster approvals for transportation infrastructure projects on which we all rely. For instance, it takes around 7 years to build a new road from our employee's house to their facility. That is delaying investment. You don't build new facilities if you don't have roads to be able to access them. Third, we want to see a commitment to developing our resources to strengthen our supply chains for critical minerals that DoD calls vital to our national defense. Fourth, we believe that EPA and the other agencies should refrain from issuing new and shifting regulations before current standards are implemented. Finally, Congress should ensure the administration follows congressional intent on recent and future statutory streamlining efforts, such as the One Federal decision. All of this should be done in a technology-neutral way. Let consumers, end users, and market conditions determine what works best. And when there must be judicial review, it should be meaningful and timely. Manufacturers believe in protecting our communities. We live there, our neighbors, and our environment. Permitting reform will help us achieve more manufacturing, more domestic energy production, more inputs and raw materials, and most importantly, more jobs. And our country and the world will be better off if we and our allies do not depend on authoritarian rivals for energy and other natural resources. The manufacturing industry will continue doing what it always does, innovating, creating jobs, and improving the quality of life for everyone. But we can do so much more with a permitting system fit for the 21st century. Thank you.
I thank the gentleman for his testimony, as well as all the other witnesses as well. So we'll now turn to questions from members. I recognize myself for 5 minutes for questions. I had the opportunity, took the opportunity, I might say, to read every word of each of the testimonies provided by our panelists here today. Mr. Ferris, I was particularly struck by one of the final paragraphs of your written testimony, and I want to highlight this. It says, permitting reform is not about cutting corners. It is about keeping up with the world around us. It's about ensuring that this country, a democracy rooted in free enterprise, is not outpaced or outflanked or overtaken by nations that do not share our values, that do not respect the environment, or that do not recognize the dignity of human rights. A little further above there, you say if the United States does not act quickly, we could lose much-needed manufacturing investment to the EU and elsewhere in the world. Can Can you expound on that a little bit? You know, what do we need in this country? Certainty? What are other attributes of a permitting system that will enable us to compete worldwide?
Thank you, Mr. Chairman. And just one example. So for mining, for critical minerals, for semiconductors, for electric vehicles, for what our Defense Department calls vital and critical to our national defense. In the U.S., a mine takes 7 to 10 years on average to permit. When you look at Australia, when you look at Canada, who has very similar permitting systems to us, very similar environmental protections, permits there take 2 to 3 years. There's certainty, and they move efficiently. There's no direct number to years that takes to permit a mine, but we know we need to do it faster, and we need to get these products working to be able to increase our jobs and increase our security.
Dr. Travnik, I was intrigued with your thoughts that you conveyed with your testimony. Can you talk a little more about the nationwide permit 12? You say one solution to ease overly stringent federal permitting requirements would be to adopt state-specific regional conditions for core nationwide permit 12, which applies to oil and gas, and nationwide permit 58, which applies to any linear utility line. Can you expound on that a little more?
Yes, thank you, Mr. Chairman. Thank you for the question. Yeah, in regards to looking at those nationwide permits and how they could be utilized, that's where we've had our agencies working with the Corps trying to discuss what it would look like from a state-specific regional condition. Knowing that there are those different regional conditions across the country, and how can we continue to utilize those nationwide permits, but knowing that, for instance, in North Dakota, we've got that unique wetland hydrological areas out there, and we are the best known with our expertise that we have at the state on what those impacts could be, and also how we're identifying what they are. So by having those type of tools in place, that will help us continue to streamline our efficiencies associated with building the infrastructure projects.
Yeah, I know in North Dakota, the weather can be a little challenging from season to season, particularly the winter season. You mentioned that Section 404 permitting delays are especially harmful in North Dakota due to our short construction season. Can you talk about that cumulative effect a little bit?
Yes, thank you, Mr. Chairman. Yes, in North Dakota right now would be our time to be starting to get out in the field, but usually that can wrap up anywhere in that October timeframe as well. So if we are delayed by any sort of decisions related to permits, we could lose a construction season or two immediately, which of course leads to increases in costs and uncertainties of when we can complete those projects. So making sure in regards to some of the discussion already on timeliness of getting those permits, that's what we would be looking for, and right now there's uncertainties with that.
Thank you much. Mr. Conway, obviously there are a lot of folks back home in my district that are concerned about rate increases. We're dealing with PFAS, new technology has been implemented there. Carbon filtration system at Cape Fear Public Utilities, I believe it cost our utility $60 million. You have major upgrades that need to be made at wastewater treatment facilities all around the country. These structures, facilities weren't designed to last 50, 100 plus years. And it seems like everything's coming due all across the board. Can you talk about the delicate balance of how do you protect ratepayers? How do you deal with the rules and regulations and what we can do to streamline this so that we are protecting water quality in every way, but also allowing for a good playing field, for you all to operate? And I only have about 10 seconds, so if you can keep it brief, sorry.
We've invested billions over the years. We intend to invest billions into the future. The key is to invest it in the right place and make sure the money is going to actual water quality improvement and protecting our communities. And really, regulatory certainty is a key to that.
I thank the gentleman, I thank the panel for entertaining my questions. Now turn to Mr. Larson.
I'm prepared with questions. I just didn't expect to cut in line in front of you.
Well, I respect the ranking member of the full committee.
Okay, thank you. I hope to continue to earn that respect. Thank you, Mr. Chair. So I want to start a question for Secretary McElwain. Can you discuss some of the positive impacts of the Clean Water state revolving fund that Maryland will be able to take advantage of over the next 5 years because we passed the bipartisan infrastructure law?
Yes, thank you. We've been able to do a lot in Maryland with the funds that have been available. We've been able to fund upgrade more wastewater treatment plants. The funding has contributed to restoration of the Chesapeake Bay. We've been able to really help the disadvantaged communities who otherwise didn't have the funding available to help upgrade the water systems that are degraded. And so the historic funding that has been available has really put us in a leading position and in a position to help the citizens of Maryland.
In some of those disadvantaged communities or underserved communities, how would you characterize the infrastructure compared to, say, a more developed area or in your state or maybe a higher economic?
They just don't have the funding to upgrade as quickly as other counties and states and local governments who have more funding. It's all about the amount of taxes that you are collecting and rates that you're charging. When you're in a disadvantaged community, you can't charge a lot in those communities, and so they're behind. They don't have the infrastructure nor the funding.
So looking at that from an opposite way, the debt limit plan that this House voted on, it would have resulted in a 23% across-the-board cut to discretionary spending, including clean water investment. What would that mean for a state like Maryland?
It would put us back, and it would mean all the funding that we have been able to, again, give to those communities, we wouldn't be able to do that at the rate in which we have been. There's a lot of investments that we have made that we have been able to forgive those loans as well because of the bipartisan infrastructure law. We wouldn't be able to forgive those loans. And again, so the economics in those communities would be, we wouldn't be able to help as much as we have been. Restoring the Chesapeake Bay, all the funding that we've put towards the Chesapeake Bay as well, that impacts disadvantaged communities as well.
Now, I recognize nothing's perfect and that there's a friendly competition about which state has the greatest estuary in America, Washington State and the Puget Sound or Chesapeake Bay in Maryland. I understand that, and maybe California. You're taking my time, John. Maybe California. That said, what work is yet to be done? And could you include in your answer some of these issues on permitting reform? What work can be done on restoration of clean water, and what work can be done on permitting reform?
So we have to meet our total maximum daily load goals by 2025 for the Chesapeake Bay. And so we work with a lot of local governments, committees, the Chesapeake Bay Foundation, Chesapeake Bay programs. We work together to find ways to continue to improve the Chesapeake Bay. If we're not able to continue to fund those programs, as well as, again, we're using money to upgrade the wastewater treatment plants. All that is pollution getting into the bay. So just going backwards, everything that we're doing is trying to move us forward, and we can't afford to have any delays in funding and contribution to eliminating pollution.
Have you looked at permitting reform in your state, and do you have some thoughts about what Congress has looked at?
In terms of permitting reform, in terms of our state, I know for my agency, we're looking at making sure that we are reforming permits. It's a federal-wide initiative, though. We realize that with the bipartisan, we meaning the federal government too, we realize that with the bipartisan infrastructure loan money, the funding, it's a lot. And you can't have projects, they're not going to get done if the permits aren't accelerated and the unnecessary steps are taken out. I've been a part of those efforts on a federal level for years, and I'm bringing that same expertise to Maryland so that, we can try and streamline the permitting process as much as we can. We're working on that now.
That's all fair. That's great. Thank you very much for helping us out today. Appreciate it. And yield back.
The gentleman yields back. Now recognize Ms. Gonzalez-Colon.
Thank you, Mr. Chairman. One of the biggest issues that, I want to say, first of all, thank you to the panel of witnesses for joining us today. And I think the Clean Water Act is one of the critical pieces of legislation that, of the past century. And to have a productive workforce and a competitive industry, we need to ensure that the resources they depend on are protected. But that doesn't mean we cannot do anything. And coming from an island that is undergoing a full recovery from hurricanes, I know how difficult it is to process the permitting between the federal agencies and the local agencies actually to get something done. So I'm glad some of the witnesses today just touch a little bit about those permitting processes. Mr. Conway, in your testimony, you bring up the Clean Water Act, National Pollutant Discharge Elimination System. And you state that these protections are threatened by opponents of a project bringing up suits against the wastewater processors based on things that were not contained in the permits. You state, to paraphrase, that utilities must not be faced with the imposition of ad hoc permitting requirements through litigation and call attention to permits that use vague language. My question will be, do you believe that this is a strategy to indirectly force the states or municipalities or regulators to take action against third parties? That is, for example, to make a regulator force an industry to shut down an activity because otherwise the public treatment plants cannot handle that discharge will be non-compliant and lose funding?
Thank you, Congresswoman. The permit system is designed to provide an opportunity for all interested stakeholders to get involved during the permitting process, including those who are going to have concerns about particular discharges or pollutants or impacts to water quality. That is a very robust process that is delegated down, that moves down into the states. EPA has various interactions depending on the delegation status of the state. But it is at that point where we really have the opportunity to protect our waters. That's the first point. Once the permit is set, the discharger has to meet those permit limits, and if it does not, it is in violation. And there are a number of compliance tools that both the state and EPA and even non-governmental organizations can take in a non-compliant situation. When you have a discharge that wasn't contemplated in the permit, and therefore there isn't a design of the system to manage that, there's an opportunity to rectify that in an updated permit, and that process is frequently undertaken by EPA and or the states, depending on the regime. So we have lots of places to check in to protect our water bodies. The big picture that we're trying to promote here is that once a permit term is set, those who have constructed, designed, and operated those systems really can't just turn them off and on to change because a new constituent is introduced. So we are really trying to work on a big ship moving down the harbor here that cleans up as much as we possibly can with the certainty we have under our permits.
You mentioned as a critique to the existing system for water standards criteria that EPA typically takes comments and subjects them to review, but because the agency takes the position that is just guidance and not rules, they do not have to follow the full procedural requirements for approving regulation, including periods for comments and responses. So my question will be are you proposing then that the law be amended to specify explicitly that EPA will approve a standard regulation through the normal administrative procedure, or do you propose that the Congress incorporate into the legislation specifics about what should be in those regulations?
Thank you for the question, ma'am. Actually, the former would be preferable, to incorporate explicitly into the Clean Water Act a opportunity for comment and participation in that process. EPA's position has been, because it's not a formal rulemaking, that the states can adopt these rules, whether if they want to adopt them, is correct. However, the states almost always do adopt those rules. They don't have the resources to come up with their own water quality research and individual assessments. So That is what we would like to see happen. I think that would be great for our communities, and frankly, for the EPA, it would be an assistance for them to have our input into that process.
Thank you. My time expired. I yield back.
Now recognize the gentlelady and my partner from California, Ms. Napolitano.
Thank you very much, Mr. Chair. Secretary McElwain, last week, the Technical Advisory Committee for the Chesapeake Bay Pollution to the Bay to address nutrient pollution if cleanup goals are to be achieved. The committee report highlighted the progress made in reducing nutrient pollution from the wastewater treatment plants, even as populations in the Bay watershed have increased. However, the report also warned that progress in addressing non-point solution sources of nutrient pollution have lagged and has been insufficient to meet the overall water quality goals of the Bay. What additional steps do you recommend for addressing ongoing non-point sources of nutrient pollution to the Bay?
First, non-point sources of pollution are the largest issue for us, for the country, because you can't detect them as quickly as you can the point sources. I think that what we need to do is prioritize the projects that have multiple benefits, and that includes carbon sequestration, ones that also have flood resiliency, as well as cleaner water. So we need to look at those projects and try to get more out of the projects that we have so that we can start addressing the non-point source issues.
For those who might suggest that additional investments in the Bay are too costly or have little economic benefit to Marylanders, how would you respond and justify the investment to all of you?
I'm sorry, repeat the last piece.
How would you respond and justify the investment when they would say that it would be too costly to do it for the Bay?
We don't have enough funding now, so it's never too costly. We need more money for investment in the Chesapeake Bay. We need to keep moving forward. We don't have room to go backwards. We have the funding that we have, as I spoke about earlier, the funding that we were able to get from the funding has allowed us to upgrade the wastewater treatment plants, improve and restore the Chesapeake Bay, help disadvantaged communities. And we have more work to do, and I had that in my testimony. There's a lot more that we need to do and that we will do.
Can you highlight the economic benefits the Bay has received?
I'm sorry?
The economic benefits the Bay has received.
The economic benefits, we've created, the Chesapeake Bay, just from the funding, I think it's 35,000 jobs have been created from the funding that we've received. So there's a lot of economic benefits that we're getting. More companies are getting more money, more loans, and again, more loan forgiveness. There's been a lot of economic benefits to the communities.
The jobs and the water quality.
And the water quality has
Anybody else?
improved.
Yes, Ranking Member Napolitano, I would say that I don't believe that anyone thinks that clean water is too costly in the broad sense, but it's important to prioritize what we have to do because it all can't be done at once. And infrastructure issues across the country, just literally delivering and taking clean water are key, absolutely key. When we start adding things, nutrients are also key, and almost all of our clean water treatment plants are set up to manage nutrients. It's a heavy lift to get them to lower and lower levels, but everyone is committed to that. Once we get to emerging contaminants like PFAS, the costs associated with that and the uncertainty in the technology right now, on top of infrastructure and nutrients, is going to put an incredible strain on our folks. And so I think prioritizing all these things and these investments is going to be very important for us.
What would the role of federal government be, or what would you expect it to be?
I'm sorry, what?
The role of federal government.
I think I would love to see the federal government set out a priorities list on pollutants. I think that would be difficult to do, but it would be something akin to setting water rights issues in the Colorado River. You can tell us what you want us to do first. We'll put every bit of energy we have into that. One of the things I would suggest is that solutions to clean water often implicate, for instance, air issues. You pollute to create clean water. You use chemicals to create clean water. And so the cleaner the water gets, the dirtier the air gets. And so we'd like to see a prioritization system that helps us guide our investments.
But then the federal government doesn't know the situation in every state, so you'd have to go differently.
I recognize that. That would
I
be.
yield back, Mr. Chair. Thank you.
Thank the gentlelady. Next up on our side is Mr. Van Orden for 5 minutes.
Thank you very much, Mr. Chairman. I find it fascinating that many of my colleagues wrap themselves in the Richard Nixon flag when it comes to the Clean Water Act, which I don't think they would normally do. When we speak about congressional intent and following congressional intent, I could not think of a greater example of that other than a bipartisan, bicameral resolution that was passed in the House and the Senate that went to President Joe Biden's desk, asking to repeal the Waters of the United States rules changes that was vetoed by President Biden. So to be clear, the intent of Congress was to not have these rule changes go through on the waters of the United States, and that was vetoed by the President of the United States. So clearly the congressional intent is not being followed by the executive branch, and that is a blatant political act, and I think it's inappropriate. Secretary, it's McWayne? McWayne, sorry, ma'am. What percentage of Maryland is dedicated to agriculture?
What percentage of Maryland is dedicated to agriculture?
Land use agriculture.
It represents a large portion of Maryland. I don't have the exact percentage, but it's huge.
Okay, Dr. Travnik, what percentage of North Dakota?
About half.
About half? Dr. Travnik, what percentage of North Dakota is dedicated to agriculture production?
Representative, so for North Dakota, yes, it's a very large percentage as well. It's our #1 industry in the state of North Dakota.
Okay. And Secretary McWayne, what percentage of Maryland would be subject to no notice, no consent inspection by the federal government if the Waters of the United States rules changes are enacted?
I would say a large percentage would be impacted. You said by the waters of the United States, by the new rule? Is that what you're asking me?
Do you have any idea, like an actual percentage?
I don't.
Okay. Dr. Travnik, what percentage of North Dakota would be subject to no notice, no consent inspection by the federal government if the rules changes of the waters of the United States were enacted?
So Representative, as we're looking at those rule changes, I mean, pretty much every industry in North Dakota would be impacted by those changes as we're looking at knowing that wetlands are now included within that new rule. We're fortunate, right, that we've got the stay right now that's not impacting our state where we're at that 2015 decision related to the Clean Water Act, but if that were to go away and if something did happen, yes, so you've got our energy industry, our agriculture industry, this agency trying to get water to people, we would be impacted.
Secretary, Madam Secretary, if you were to consider Maryland in relationship to North Dakota, would you say that Maryland is more heavily regulated than North Dakota?
I'm sorry, can you repeat the last piece?
If you were to juxtapose Maryland with the state of North Dakota, would you say that Maryland is more heavily regulated than the state of North Dakota? I know what Dr. Travnik is going to say.
I'm not sure.
Dr. Travnik, in relationship to Maryland, would you say that Maryland is more heavily regulated than North Dakota?
As Representative, so I do not know all the regulations that are within Maryland, but as we're looking at regulation in North Dakota, we're always trying to do the innovation over regulation. That is what we're always looking for. We're looking to try to streamline our permitting processes, making sure that we can get infrastructure to the different economies that we're striving for within the state.
Thank you. Madam Secretary, do you think that the regulations that apply to the state of Maryland should apply to the state of North Dakota?
I mean, I look at it, well, because we're trying to protect upstream states from polluting downstream. So,
Madam Secretary, is North Dakota upstream from Maryland?
well, my point was
I understand your point, ma'am. Here's my point. We are a part of a republic. So Dr. Travnik, when she's speaking about the regulations that apply to the people in North Dakota, I don't think that she should be able to tell you what to do. And I don't think you should be able to tell her what to do, because you live in very unique states. I appreciate everything that you're saying. I appreciate what you're saying. But there is a very specific reason that our Constitution was written the way that it was. And I do not think the federal government has a place in dictating how you should live your life, nor Dr. Travnik's in relationship to the waters of the United States. And the answer to Wisconsin is 85% of the 3rd District of the state of Wisconsin will be subject to no notice, no consent inspection by the federal government if these rules changes took place. Thank you very much. I yield back my time that has already expired, Mr. Chairman.
The gentleman yields. Mr. Gurmandy.
No, I'm not going to do it. I'm not going to engage in the debate about the role of the federal government versus the state governments and the like. I'll just let that go for a few moments. So we are talking about reform here of the various permitting processes. I actually do have a reform. I'd like to have all of you comment upon it. Presently, the NEPIDS permit is for 5 years. And so, Mr. Conway, you and your agencies and others seek a permit to discharge, and it's 5 years. About the time you get underway on the construction of whatever it is you want to do, it's now time for another 5-year permit. And so you are constantly permitting. The reform that we have is in HR 1181, which would, instead of a 5-year, give a 10-year permit for the discharge for the public agencies. We think it's a pretty good idea. We want to get these projects underway. If there's an upgrade necessary, then get about doing it without having to once again, within that 5-year period, start all over. So we're looking at a 10-year permit. And Mr. Conway, if you could comment on this. Previously, your organization endorsed it. It's a new Congress. We're going to give it another try. Chairman Rouser, we'd love to have your support on this. Mr. Conway.
Thank you, Congressman. I know NACWA has been in support of that idea, that any increase in certainty, any increase in lead times to plan, execute, and operate projects would be, in our world, helpful. Frankly, the reality, to your point, is that if you're going to add, for instance, tertiary treatment to a large wastewater treatment plant, that's a 10-year process in and of itself to get to those low limits. So that longer lead time and run time would be very helpful for utilities.
Thank you. The other witnesses, if you care to comment about this issue of moving from a 5-year NEPIDS deadline or permit to a 10-year, please do. Dr. Travick.
Representative, so as you're looking at that 5-year to 10-year permit, of course, you get more of that certainty of being able to stay within that bounds of a longer one. But that would be my comment at this point.
Thank you. Secretary McElwain, why did you leave California to come to Maryland? You were doing such a good job in California. But here you are. So your comments?
I'll just comment on that.
Let that go.
I came to Maryland because Maryland is home for me. I love California, but I had to return home and make sure that I'm protecting the environment in Maryland.
Well, carry on then. What about this 10-year permit versus a 5-year permit?
I don't really have a comment on that. I have thoughts, but I rather
Well, I'll
keep my
send
comments to
you all
myself.
of the information. You can then comment in writing later on.
Okay.
Mr. Ferris?
Congressman, one thing that manufacturers constantly ask for is regulatory certainty. This would give them certainty. Yes, sir. Absolutely.
At least within the 10-year period of time.
Yes, sir.
So the projects can actually get underway, the construction can begin, completed hopefully within that period of time. And there'll be another opportunity. Any changes that have occurred in the standards, the emission standards, could be dealt with subsequently. Mr. Rouser, love to have your support on this. As part of our reform, it'd be great to include this in it. With that, I yield back.
The gentleman yields. Mr. Babin.
Thank you, Mr. Chairman. I really appreciate it. Thank all of you witnesses for being here as well. We appreciate your testimony. Mr. Ferris, given your role with the National Association of Manufacturers, I'd like to hear your perspective on a few challenges that are being faced by our manufacturers today in our country. Members of the committee have heard people from many different economic sectors detail their frustrations with our permitting processes. And from your perspective, what are the main challenges faced by manufacturers in the United States due to this permitting process?
Thank you, Congressman, and how much time do you have, sir?
Well, I've got several more questions, so just maybe just hit the high
So
points.
I can say the biggest thing is the delays. We have had one member who had to delay being issued an U.S. Army Corps of Engineer permit merely because the U.S. Fish and Wildlife Service wouldn't give them informal paperwork saying that there's no environmental impact. So for a year, potential workers sat on the sidelines. A community lost out on economic opportunity for informal paperwork that should have taken 90 days.
Yes, absolutely. Critical minerals are something more and more Americans are becoming aware of now that we're seeing some really news stuff on this. Our reliance on Chinese companies in the critical mineral supply chain is dangerous and potentially disastrous as China continues to aggressively come after the American economy. Generally speaking, how is the reliance on Chinese critical minerals impacting our manufacturing capabilities, and how is the inconsistent administration of critical mineral policies impacting the industry?
Significantly, significantly. If we learned anything over the past 3 years, it's about supply chain, and it's about manufacturing more things in America. As a country, we've agreed we need to manufacture semiconductors. We need to manufacture batteries. We cannot do those without the critical minerals. And as I mentioned earlier, right now in the U.S., it takes 7 to 10 years to get a mine permitted. In Canada, 2 to 3. In Australia, 2 to 3. That's how we lose on an international scale.
Absolutely. Last question. If you could leave myself and my fellow members on the committee here with one key takeaway today, what steps do you recommend that would help our manufacturers? And what steps should we take to help our manufacturers?
I would say the two guiding principles are deadlines. Deadlines because that creates certainty, and then judicial review. There needs to be judicial review. It needs to be meaningful and timely. And those are our two guiding principles for permit reform, sir.
Okay. Anything else you'd like to add? Because I've still got a little time.
I just wanted to say thank you to the committee and thank you for your leadership on these issues. This is something that I believe is a bipartisan issue and that we all need to know that we need to figure out how to fix.
Absolutely should be bipartisan, and our economy and the American and national security are dependent upon that. Thank you, Mr. Chairman, and I yield back.
The gentleman yields. Ms. Sykes.
Thank you, Mr. Chair, and thank you for the panel for coming to testify today. This has been a riveting conversation. As many of us here, we are deeply concerned about the bipartisan infrastructure law and ensuring that we are able to complete these projects. It is especially important in communities like mine and in Ohio who continue to struggle with water quality. And I know the Clean Water Act was especially important for us. Not my city, but we've heard about the mistake on the lake when a lake catches on fire or alga blooms in the northwestern part of the district or the state, where we are constantly trying to keep mineral deposits and overgrowths that negatively impact our water supply. So I appreciate all of you being here to discuss this very important role of the Infrastructure Act. And specifically, I'm going to go off script just a little bit because Mr. Ferris, you had a very interesting point to the question about permitting, and I know we're trying to get to the root cause of why the permitting is taking so long and why we can't get these projects done, even though that we have the resources for it. And you've specifically mentioned delays. Now, I want to ask you a question about the debt bill that was recently passed out from this Congress, because what we understand is there will be about 22% cuts across the board. And I heard you mention the Army Corps engineers, which would mean eliminating employment and employment opportunities for people to move those permitting requests through. You talked about the judicial process. You talked about some other federal agencies. But with the 22% cut across the board, which would ultimately mean decimating the workforce, it would seem like the delays would only increase. Is that correct? Yes or no, Mr. Ferris?
Ma'am, what we're seeing across
Yes or
the
no, Mr.
board
Ferris?
is yes.
Mr. Ferris, yes.
Yes, yes.
Yes, okay,
Stephanie.
so it seems like the bill that we got from the majority would only exacerbate the permitting process and making it longer, yes or no?
I cannot comment on that. What I can say is that on the debt ceiling, the NAM supports the full faith and credit of the United States cannot be questioned. We also support permitting reform, and we would love Congress to figure out how to be able to do both.
Thank you, Mr. Ferris. I appreciate you saying that because I do hope that the speaker is willing to do the work to make sure that we get that done and that we do maintain the full faith and credit of the United States. I will answer the question for you since you would not, it would in fact make your permitting process much longer and exacerbate the process and make it much more difficult for you to do the manufacturing that you want. Semiconductors in Ohio are incredibly important. Bridge and road building is incredibly important in Ohio with so many highway and byways and center lane miles. It is going to be very detrimental. So I do hope that we have the full picture as we're talking about that question. But Mr. Conway and Madam Secretary, perhaps this next question is for you because water affordability continues to be a problem for folks all across the country, whether you're in urban areas where I represent, suburban areas where I also represent, as well as rural areas where I represent. And so I just want to talk to you and ask you the question of what happens if we fail to pay the bills as a country and we don't have the resources to continue to fund these projects? How are people going to afford water, clean water, in their communities? And Mr. Conway, I'll start with you, and Madam Secretary, if you wouldn't mind finishing.
Thank you, Congresswoman. Obviously, our funding structure is primarily our ratepayers. We do have some assistance from state. Many in our state use federal funds as well through the SRF. It's very important for those utilities to be able to use those funds, the Infrastructure Act funds flowing through there. As those funds decrease, then again, we have to get to really high priority projects only. You do see that there have been failing water systems around the country that were not able to continually invest in their systems, and then you reach a point where, frankly, there's an emergency in delivering those services. The burden on ratepayers can only go so far. Folks will not pay their bills at a certain point, and we do see that in emergency times and difficult economic times. And so ultimately there becomes a spot where you can only invest the funds you have, and you're holding on and putting Band-Aids on things. So funding is critical to make all this work.
Thank you, Mr. Conway. Madam Secretary.
Yes, the bipartisan infrastructure loans help make the projects affordable in the disadvantaged communities. And so without the funding, again, I said it earlier, but to even think about raising the rates in some of these communities would be an economic disaster for those families.
Thank you, Madam Secretary. And again, just want to highlight how important it is for us to figure out the debt ceiling and not move forward with what we passed here in the House. And my community specifically relies upon low interest and no interest loans to keep our ratepayers from not having to pay more so that they can actually afford not only their water, their housing, their gas, their groceries, and all those important things. Thank you, Mr. Chair. I yield back.
Mr. Westerman.
Thank you, Mr. Chairman, and thank you to the witnesses today. Mr. Conway, last month, the Arkansas Water and Wastewater Association visited my office and mentioned its members have concerns about EPA PFAS regulation under CERCLA and how that would affect their operations. As processors in the water system, can you talk more about how water utilities are going to have to navigate this potential situation?
Thank you, Mr. Congressman. The potential CERCLA issue for water and wastewater providers is a really serious issue for us. We are passive receivers of PFAS. It comes from uses in products and in some cases industrial. In my particular jurisdiction, it's almost all domestic use that's sending PFAS into the system. Then the PFAS, because we do not have technology to take it out of wastewater, it passes into the biosolids and it passes into the liquid stream in some part. We're probably many years away from a large wastewater plant such as mine being able to manage PFAS, and we're working as hard as we can to get there. But to the extent that CERCLA liability attaches to anything that comes out of our publicly owned plant, costs our ratepayers a tremendous amount. Effectively, they would be paying to be poisoned. And without a CERCLA exemption for wastewater and water treatment, folks, the public is just going to pay for the cleanup of a product that was manufactured by other people.
So you think there are exemptions from CERCLA for wastewater treatment plants that should be considered by Congress?
I believe that Congress could consider an exemption for publicly owned wastewater and water treatment plants, yes. I think that would be appropriate.
And talking about wastewater treatment, and I'm going to transition to Mr. Ferris here, but I remember a few years back we had a hearing, and I think it was somebody from the city of Spokane testified about regulations that were being put out by the state of Washington. And I believe it was dioxin they were regulating, which we all know dioxin's bad, but the regulations actually required levels below an amount that you could test for. Like, it was impossible to even test for the levels that were being stipulated in this regulation. And you very well described what the permitting process is like in the real world. That's where I came from doing engineering work. I worked on air discharge permits, water discharge permits, waded through the mountains of paperwork, waited on agencies to reply back, having to correct their mistakes and help them through. You talked about how permitting is hurting transportation, how it's hurting energy, how it's hurting resource development. And then you talked about the importance of judicial review and having it done timely. I agree with all of that. I want you to go into a little bit more detail. There was a section in your testimony where you talked about PM 2.5. Well, and just explain what this is like in what I call the real world, because I saw this in my engineering career go from best available technology to maximum available control technology. And you get to a point where you're spending extraordinary amounts of money for small amounts of gain in the reduction of particulates. Can you tell, when PM 2.5, what size are those particles?
So think of a strand of hair, and that's 4 times as large as, much larger than anything on the PM 2.5. And thank you for the question. So we have recently commissioned a study with the Oxford Economics on the PM 2.5 and the regulations. And what we see there is at the level of 12 right now where it's at and where EPA wants to go, it will take more than 40% of our entire population into areas of non-attainment.
And that means, just so people understand, non-attainment means you cannot emit any more particulates in an area that's a non-attainment zone. So when business looks at that, they say, well, we can't build here, we'll go somewhere else. What does that do to economic growth?
We have a story with a member. They were forced to spend $400 million. They wanted to build a new facility in an area that was currently in non-attainment. This is before the new rule came out. And they would have had to spend $400 million just to be able to get the air within attainment. What they ended up doing was they moved it at a cost of $100 million and caused a 6-month delay in the project.
And when you throw this out and say attainment, non-attainment, and people might think, well, they should just spend all of that because it's for the good of society, but I don't think people realize that the minuscule benefit that you get for investing all of that capital, and it never stops. The goalpost always moves, and there's always some new technology out there. And I know I'm out of time, but I was just going to ask, how far ahead of the rest of the world are we on reducing particulate emissions where we're already at?
Thank you, and quickly, on the study, it showed that we are amongst the best and the cleanest in the world in manufacturing.
Thank you.
Ms. Schulten, you're recognized for 5 minutes.
Thank you, Mr. Chair, and thank you so much to our witnesses for helping us understand the critical role of the Clean Water Act. Water is a way of life in Michigan. The district that I represent is part of the Great Lakes watershed and supplies fresh water and related natural resources not only for Michiganders and West Michiganders, but truly for the entire country. We know that the value of our water in Michigan's 3rd Congressional District is at a premium. Unfortunately, PFAS contamination is also a prevalent concern. Just yesterday, the Michigan PFAS Action Response Team identified 3 more areas of concern in West Michigan. The safety of our drinking water and the health of our communities is at stake. My first question is for you, Mr. Conway. In your testimony, you talk about the financial impact of cleaning up PFAS in cities and towns. Can you talk a little bit more about those costs? What are the costs that these cities and towns are incurring, and how can municipalities, localities go about accessing dollars from the bipartisan infrastructure law to cover them?
Thank you, Mr. Congressman. Currently, the drinking water folks are experiencing a little bit different process than the wastewater folks. In wastewater, we are in a sampling and testing phase. We're finding out what's in the influent and effluent. And the challenges in testing are significant. Testing methodologies are still being approved. Very few labs actually go through this testing process, so there's a premium on getting the right labs and the cost of doing that. And many of the smaller systems are being really heavily burdened by just the costs involved with just finding out how much PFAS is in their system. So to the extent that infrastructure or other federal funds can be designated, not just for capital projects associated with PFAS, but for finding out what's in the stream and what we're going to do with it before we start building things, that would be really helpful for large and small utilities. I think one of the big challenges in the long term here is going to be that this is not just a capital construction cost issue, it's going to be an operational cost issue. The current technology is filtration, which for drinking water systems is possible because they have pretty clean water sources. Wastewater are much more difficult for large systems. And managing the operating costs of constantly changing filters, and then, frankly, what are we going to do with this stuff? That has not been determined by EPA or anybody else. That could be a significant cost, especially if circular liability attaches to PFAS. Landfills may not take it. I don't know what we'll do with it. So the cost centers are really around those areas right now in the wastewater community.
Thank you. My second question is for Secretary McElwain, and it pertains to new infrastructure improving water quality. As of 2021, Michigan is estimated to have close to 500,000 lead pipes currently carrying water. In Michigan, we saw up close the devastating impacts of lead on children during the Flint water crisis. While I'm proud of the progress that the state is making in cleaning up our water supply, I represent a district, a zip code, the 49507 region of Grand Rapids, that's ranked the second worst in the state for the number of children aged 5 or younger that have elevated lead levels in their blood. While efforts have begun to replace these pipes that lead to homes in this zip code, it remains one of the most underserved and gentrified zip codes in my city, which is part of why contamination levels got so bad in the first place. It's here where I see the social and environmental determinants of health negatively impacting families across the city. So my question for you is, how are you ensuring that water quality improvement efforts are being equitably implemented?
Well, we have the same issues with lead, but we have a robust program as well in terms of lead protection for children. We have an EJ, an environmental screen tool that we use for a variety of things. We use it for grants and for funding. We can also see where we're starting to add health indicators into those environmental screens, so we do use that to identify, but we do have a system in place where we're looking at where can those funds be most utilized, and it is in those areas where we can see children are suffering the most.
Thank you. My time is about up, so I yield back.
Gentlelady yields back. Mr. Ezel, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate the committee continue to highlight how the permitting process is creating harmful delays for critical infrastructure projects across the country. Since I've been on this committee, it seems like that's what we talk about every time this permit. Costs are getting higher and timelines are getting longer, both because of the uncertainty placed on the industry by the Biden administration. Mr. Ferris, the aggregates industry plays an important role in building our nation's infrastructure. How does the current interpretation of the Clean Water Act potentially affect the procurement and use of building materials such as aggregates, which are vital to public works projects that benefit South Mississippi, like water treatment systems and flood control?
Sorry, one more time, sir.
How does the current interpretation of the Clean Water Act potentially affect the procurement and use of building materials such as aggregates, which are vital to public works projects that benefit South Mississippi, like water treatment systems and flood control?
Thank you, sir. What we see is delays up and down the board when whether you're getting equipment, whether you're preparing your permits, whether you're building a road to your facility. The current process creates delays, whether it's 4 years, 4.5, 7 years. That builds uncertainty into this process, and that means that the jobs aren't happening in those areas.
Thank you. Considering the potential impact of the Clean Water Act's current interpretation on infrastructure projects that depend on aggregate materials, what recommendations would you make for a more balanced interpretation that still protects our water resources?
What we've seen that deadlines can work. We've seen in other countries that have environmental protections that are similar to us, they can get things done in 2 to 3 years when we get them done in 7 to 10. So deadlines that we have to meet, along with the one federal decision. Make one agency in charge of this, everyone answers to them. What we've seen up and down the board is other agencies not getting in informal paperwork, other agencies not coordinating. So we need one federal decision, and we need some hard deadlines for them to be able to meet, sir.
Thank you. Dr. Travanik, given that aggregate materials are a key component of many public infrastructure projects, can you discuss the potential consequences of an overly expansive and unclear interpretation of the Clean Water Act?
So as we're looking at the expansive with the Clean Water Act, and you're looking at infrastructure, so yeah, it comes down to those permits, those timelines, trying to make sure that that's a consistent process for us to go through, because right now that leads to issues with supply chains that might happen, also getting contractors on site. So if there's some issues that come up with not being able to have the permit in place, it leads to the delays. So that's where just having some of that consistency.
Thank you very much. Mr. Chairman, I yield back.
The gentleman yields back. Mr. Burleson, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I wasn't ready, but I do have questions. So this is also for Dr. Travanik?
Trebnik, yep.
Okay. I came from the state legislature. I'm a 10th Amendment guy. Do you believe that states play an important role, when it comes to protecting their own waters? And how do states like your state of North Dakota care for your waters?
So absolutely. I mean, we do have the state agencies in place that do have regulatory responsibilities, from the Department of Environmental Quality Act to Department of Water Resources. We have the expertise. We're looking to also make sure that we've got good quality water, good water quantity. So we look at those expertise. So yes, so we want to make sure, that's why we're always stressing the state's rights, making sure that you're utilizing our expertise. We're the ones that are boots on the ground, so working with us.
But they're the ones that actually live there and know the area, and I think all politics is local. Okay, next question for Mr. Ferris. What challenges are the manufacturers in the United States facing due to the current permitting process?
We are facing delays. What we've decided in this country is we need to build more semiconductors. We need to build more batteries. And that process right now is 4.5 years to create an environmental impact statement. We need to build these yesterday. So we're seeing massive delays throughout the permitting process, and we're seeing agencies that don't talk to each other. We're seeing informal paperwork being delayed that should take no more than 90 days, sir.
And so this is a no-brainer, but that affects your association's ability to create jobs.
And that affects every one of our members' abilities to create jobs and improve the local communities in which they operate.
What about energy projects, including renewable energy sources? What are the potential consequences of delays there, or what's happening with those?
To be able to get many of these renewable energy sources on board, we need transmission lines. We need to be able to take that power where it's produced and take it to where we need it. Transmission lines can take 15 years to permit. So if we bring on a new solar facility or a new hydrogen facility, you still need the transmission lines. And even within itself, a hydrogen facility takes 4.5 years for the environmental impact statement. Takes a year to build and operate. 4.5 years for that, plus another 15 for transmission lines, and that shows you the type problem we have here.
Yeah, and with transmission lines, you have to acquire the land, which takes time.
It does, it does.
And so at a time when we have more critical needs than ever, and we need to be mining and harvesting everything that we can here in the United States, how can we improve the regulations within the Clean Water Act?
What we need is enforceable deadlines. If there is judicial review, it needs to be meaningful and timely. Deadlines will go a long way, as well as one federal decision. Make sure that one agency is in charge, everyone answers to that one agency, and so they coordinate with everyone else involved. They get the informal paperwork from the other agencies. So those two aspects will take us a lot of the way there.
Thank you, Mr. Ferris. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Mr. James, you're recognized for 5 minutes.
Thank you, Mr. Chairman. First of all, I want to thank all the witnesses who are here with us today and graciously devoting your time to be here and in your everyday life to improve water quality for all Americans in your neck of the woods. Your expertise is not only valuable, but it also informs us about the real-world implications of the Clean Water Act. In Michigan's 10th Congressional District, I represent a district that's not only diverse in its people, but one is blessed with the rich natural resources from Lake St. Clair to the Great Lakes. Michigan's natural beauty is second to none, which is why I lead off by asking the question. We have to be able to take care of everyone. Clean water is something that's important for all humankind, especially when communities are struggling financially. When we talk about these communities being impacted by the Clean Water Act over the years, I would appreciate getting feedback from the panel on the unique challenges that we're still using to manage combined sewer overflows, that storm sewer separation, some of the best practices that you've either deployed or seen, and also with the storm sewer separation with what we're putting back into our rivers and to our lakes to improve that. Also, some of the technologies that you've seen across the country and across the world that puts water back into our estuaries, aquifers, rivers, lakes, cleaner than we found it. Ladies first, please.
Yes, Representative. So the agency that I'm working with, we don't get into is the storm sewer as much as some of the other ones might. But as you're looking at critical infrastructure and trying to make sure that you're capturing the water quality aspect, whether it's trying to make sure that we're protecting some of those waters, but also at the same time looking at water reuse. So how do we put that into other uses as well? But my biggest thing as you're looking at the infrastructure is tying back to the permits. So the costs that go with it would be the biggest thing that on my end, looking for those inconsistencies, making sure that we're streamlining, because that's going into your costs as you are looking at that infrastructure that you're looking for, because that's also adding to it. So that's what I would have. Thank you.
Thank you.
Oh.
Yes, please.
Okay, I'm sorry. Can you repeat the last piece of your question?
So, two-part. One, if you have any experience with storm sewer separation, those combined sewer overflows, which are contributing in many cases to the algal blooms that you mentioned in your opening statement, and also linked by other bacterial growth, that's storm sewer separation. If you've seen instances in your experiences of where that has been done better, you mentioned the Chesapeake Bay. If you have some experience in some of that separation, and also in the region, just as a hint, North Carolina, I understand, did some. I understand Maryland completely separate, but just on the Atlantic coast, North Carolina experienced some success with using technology to clean the Cape Fear water, to clean out things like PFAS. Can you speak on that, Madam Secretary? Anything of those modern technologies that can help us put water back cleaner?
Yes, well, for one, we need to continue to increase hydraulic capacity and infrastructure. The Back River that we deal with a lot is the wastewater treatment. It has a headworks program that captures a flow and it reduces basement backups that you talked about in sewages and those kinds of things. So we are using technologies. We have used a lot of funding in the bipartisan infrastructure law to upgrade the wastewater treatment plants and to deal with those issues. And we just passed legislation for potable use as well. So potable reuse.
Thank you, Madam Secretary. Gentlemen, in the last minute that we have, can you speak specifically, any tactics, techniques, procedures, any best practices you've seen in addressing specifically, or what the federal government could do to address lower income communities, communities that are in economic distress, the areas that the federal government can help with clean water in those areas?
Speaking on behalf of NACWA, there are a number, especially in the combined system areas, there are a number of projects that are being completed in certain stages of completion, long-term control plans. Funding is critical for those to be successful. Obviously, costs in the last year have skyrocketed, so estimates of cost for a project in the next 5 years were, $1 billion. Now we're finding it's $2 billion. So any increase in funding, because those projects are modern technologies being employed, they're increasing capacity, they're using AI, they're allowing those rivers and streams that get those discharges to be a lot cleaner. So it's just strictly a funding equation there.
Thank you, Mr. Conway. Mr. Ferris will reach out offline. Thank you, Mr. Chair. I yield.
The gentleman yields. Mr. Williams, 5 minutes.
Thank you, Mr. Chairman. I'm glad to be here. Mr. Ferris, specifically in my district, recently a large chip manufacturer has announced a significant, extremely significant and historic investment. And one of the deciding factors was the availability of water. And clearly that's used in a lot of manufacturing processes that I'm familiar with, and a little bit familiar with some of the testing and treatment of wastewaters. As it regards to your organizations that you work with, manufacturers, how would you compare the discharge of the quality of water, the cleanness of water, discharge from your facilities today than, say, 50 years ago? What's happened in the last 50 years in terms of water quality and water standards in manufacturing?
In manufacturing, over the last 50 years, we've improved, I believe it's around 80%. We are amongst the cleanest in the world. I can get you, offline, I can get you that accurate number, but I believe it's around 80% amongst the cleanest in the world.
And 80% in what metrics? Would you generally, what are pollutants that are concerned about? These are chemicals, metals, turbidity. What are some of the things?
Absolutely, all of the above. Anything that is regulated and discharged into the waterways, we are about 80% better than we were 50 years ago, and constantly improving. Manufacturers are constantly innovating and finding new ways to be able to be a good environmental steward of the environment they work in.
I understand that a lot of manufacturing also recycles a lot of its water to reduce its waste stream. Do you have any specific examples or context that you can give our committee about how manufacturing stewards this resource of water, particularly in consuming less and discharging it cleaner, has been the practice?
We can follow up you directly on some more detailed stories, but I can say that manufacturers are constantly innovating, and recycling water is one of those pieces. We're constantly working to improve the environment around us, but we'll follow up with you directly some more stories.
Great, thank you. Does your organization also cover the aggregate industry?
Yes, so we have 14,000 members. We represent everything from the 5-person manufacturing facility all the way up to some of the biggest across all sectors.
So in my district, we have not only this historic, potentially $100 billion investment in manufacturing and the supporting infrastructure around it, we also have a major overhaul of I-81 running right through the middle of Syracuse, obviously a very significant construction project. Can you describe the role that aggregate plays? What is aggregate? What is it used for?
I would say I would defer to you, sir.
Okay, well, you know, it's sand and gravel basically used as different compounds and building blocks, specifically in concrete. And it adds strength and durability. And there are no streets, there are no buildings, there are no sidewalks, there are no parking lots, there are no dams without concrete. And one of the key ingredients is what's commonly called aggregates, which is all different sizes. Think of it as different size stones and different size sand, all that make up the physical structure of concrete, as has been the case for over 2,000 years, right? The Romans first started using that, and many of those, their monuments still stand. But when we're making this trade-off in terms of clean water, I understand that the mining industry also is subject to very strict water rules and water discharge rules, particularly around something known as T-clip, which maybe you're familiar with in terms of heavy metals. Can you describe how your organization, I don't know, leans in to these testing and water quality standards? And how is it important that these are very clear standards for you to adhere to, for your clients to adhere to?
So what we do is we work with manufacturers, we work on best practices, and we often work with EPA or other regulatory bodies to make sure that these standards are technically achievable and technically feasible. They're very important for our members because all of our members ask for regulatory certainty, so we need to make sure that our members understand them and are able to meet them.
Great, thank you. I yield back.
Gentleman's time has expired. Garrett Graves, 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, thank you for holding this hearing. Ranking Member Napolitano, nice to see you as well. Dr. Travnik, I understand you've got some experience with 404 permits. We have more than our share of wetlands in Louisiana as well. In the IIJA, there was about $160 million provided for the Corps of Engineers for regulatory, which is about 50% of their budget. I'm not sure that I've seen any improvements in their 404 process, and I was just curious if you've seen anything in North Dakota. And as I remember in North Dakota, I got to tell you, thank you for sending Kelly Armstrong. Huge fan. He's been fantastic.
Yes, we're very fortunate to have his leadership in the state. So as it relates to what we're seeing in North Dakota with the Army Corps of Engineers and the 404 permitting, we haven't seen anything that has sped up any of the processes. I think we are still seeing those delay and timelines. And if this were to go into place, right, that's why we're nervous about that. I mean, even with the other permits that I have to get through the Army Corps of Engineers for the water infrastructure projects, we don't know when we'll get them sometimes. We try to make sure that we're trying to pin them down on a timeline, but sometimes that gets passed. So we haven't seen anything that's been able to turn that around quickly.
And I think that there are some mitigation banks that have been in the process for 10 years now, which of course causes some additional problems. Secretary McElwain, thanks for being here. I was looking at the Maryland One Stop program where you have an electronic regulatory process. And I didn't know if you could provide any background. We've actually been looking at an electronic NEPA for the federal process as a way to try and help with compliance and better transparency. I just didn't know if you had any wisdom or insight to share in regard to your Maryland one-stop process for permitting, if there are any lessons learned there for helping to just improve efficiency.
I could only speak in general terms about increasing efficiency. That's something that I brought to every agency I've been at. I would have to look into when I can provide that with you to you later, but I don't have any direct knowledge of that.
Sure. Secretary, maybe I misunderstood, but I thought y'all had Maryland One Stop was kind of a one-stop electronic permitting process that y'all had. And again, we're trying to figure out at the federal level what we can do to help expedite the permitting at the federal level, and again, better transparency as well. And so if y'all do have any lessons learned, that'd be great. Love to hear it. If not, no problem. No need to follow up. But a quick follow-up for you maybe. So the reality is when you look across infrastructure projects across the United States, the majority of those projects actually don't require a NEPA analysis, a National Environmental Policy Act analysis, because the only cases when NEPA is triggered is when you impact certain federal resources. It could be dollars, it could be federal natural resources, it could be federal permits. And so most projects don't trigger that because they're using local funds, state funds, or private funds, and so it doesn't trigger NEPA. But I know in Maryland, y'all care about the environment like we do in Louisiana. So I'm just curious if you could share any insight to your state laws that help to ensure protection of the environment for projects that are built that may not trigger federal permits or federal regulatory implications.
Well, we monitor, we have comprehensive wetland laws. And back to what you were referring to with the one-stop permit, that doesn't, if I understand your question, that doesn't apply to all the permits that we have. We have a general construction permit, and so it just depends on what kind of permit that you're talking about. Yeah, but in terms of permitting and NIPD's permits, we look at the laws, and we have state reviews and environmental reviews, and just like NEPA. So we definitely take a comprehensive look at permits.
And obviously protection of the environment, even if there's a project that doesn't trigger federal regulatory, your state process would ensure that your state process would ensure that you do consider protection of the environment.
Of course.
As well. Yeah. Okay. Great. Thank you. I want to go back. There was a gentlelady who a little while ago made comments about the debt ceiling legislation and suggested, Mr. Chairman, that the debt ceiling legislation would actually cause more problems, would delay permitting and things like that. And I just wanted to be clear on the record that those comments fundamentally misrepresented what was in that legislation. That legislation actually helps to focus the NEPA process on the environment rather than all of these other ancillary things. And in doing so, you actually would expedite permitting, expedite the NEPA process. It puts in a timeline of 2 years for an environmental impact statement, 1 year for an environmental assessment. I want to make note, when Jimmy Carter was president, you had 1 year under his regulatory guidance to get through the NEPA process. We've allowed for 2 years under an environmental impact statement. And so while I certainly appreciate the gentlelady's concerns about regulatory, I did want to make note that that those comments did significantly misrepresent the legislation known as the Builder Act that passed this part of H.R. 1 earlier this year. Mr. Chairman, I have a question. I know that there's additional information that folks would like to get from our expert witnesses today. Is it possible that we have a second round of questions?
Yes. Yes, we're going to have a second round.
Fantabulous. Yield back, and I'll wait for a second round.
Thank you. Do we have any other questions? Mr. Graves, you're recognized for 5 minutes.
Hey, look at that. Thank you very much. I'm curious. One of the biggest challenges we have with permitting is regulatory certainty. You have folks that have resources or investment dollars that are trying to be invested and move projects forward. It was noted by Dr. Travnik that in many cases, your permitting is a black box or a black hole where you don't have any idea on permitting certainty. Mr. Ferris, I'm curious, as of September 2021, there are about 300 permits in the EPA backlog for reissuance, affecting about 14,000 facilities nationwide. We did pass legislation under H.R. 1 that would extend administrative continuances on EPA for 402 authority. Can you talk a little bit about concerns on what you're seeing right now with Clean Water Act compliance and just delays or uncertainty regarding timelines for multiple permits, and how NAM may be looking at this?
Absolutely, thank you, and thank you for your leadership on HR 1. The NAM was happy to support that, and that makes some meaningful changes. What we're seeing on Clean Water Act is the same thing we're seeing up and down the board on permitting. We're seeing delays, and we're seeing uncertainty, regulatory uncertainty, which causes investment decisions to be made elsewhere. We have one member who was working through the 402 permitting process. They make raw materials that are critical for semiconductors, for lithium-ion batteries, for electric vehicles, for hydrogen, and they wanted to be able to build that facility in the U.S. Because of the uncertainty surrounding the so-called NIPDES permit, the discharge permit, they were not able to do that in a certain amount of time, and so they ended up building that facility in the EU that makes raw materials for clean hydrogen. We're seeing that up and down the board is when our manufacturers have to make investment decisions, they need to be able to make it in a timely manner. And when they start looking at the environmental impact statements that take on average 4.5 years, then they may start to look elsewhere when they make those investment decisions.
So, Mr. Ferris, let me see if I can make sure I'm understanding what you're saying. So companies are going to build their projects, but if we have regulatory uncertainty, or if we have delays, or if we have repeated rejections, or as I've seen, repeated hurdles thrown up, then what these investors or companies are going to do is they're still going to build the project, they're just going to build it elsewhere. And you noted an EU example, but I am going to guess that there are probably companies that have taken their investment decisions to Mexico, Brazil, India, China, and other countries that don't have the same environmental conscience that we do in the United States. Therefore, if you're concerned about the global environment, then our delays or our lack of regulatory certainty actually is resulting in a net loss for the global environment. Is that fair?
100%. When you build in America, we have amongst the cleanest manufacturing in the world. When you build elsewhere, you don't have to meet those same standards. You mentioned China. That's a perfect example of not having to meet the same standards we have here. And many of our members are global members, so they are going to build these facilities to meet this demand. Semiconductors are being made everywhere. We want to make them in the U.S. If we take a critical raw material and take it overseas, we're just affecting where our issues in the supply chain are.
Got it. So I'm curious, Mr. Conway, Mr. Ferris, have either of you all seen any changes? I noted $160 million provided to the Corps of Engineers for regulatory under the IIJA. As I recall, there was $1 billion for regulatory agencies across the board provided for compliance. Have either of you seen any improvements or efficiency with those additional funds to the agencies?
Not yet. I would assume that some of those funds are still being distributed. It takes time to hire, especially these days. It's hard to get people moving into positions and onboarded and trained. So we expect at the local level at least to have some relief on regulatory issues because in Colorado we deal with our state for permitting as opposed to the federal government on permitting projects. We're more focused on state dollars there, so we haven't seen that.
Mr. Conway, do you have any feedback on an electronic permitting system, if you think that would be something that's helpful at the federal level?
I'm not familiar with Maryland's system, but any improvements that would add to efficiencies to speed time, I would be in favor of.
Yeah, great. Mr. Ferris, any reaction to that?
Completely agree. Anything that can give our manufacturers more certainty and a speedier process, we are in favor of.
Secretary McElwain, Maryland has a law similar to Louisiana where they allow for performance-based contracting on environmental restoration or ecological restoration. If you don't, I don't want to put you on the spot, but if you don't mind, I'd be curious if you could provide the committee with some information on how that has worked, if it has been a benefit to the state of Maryland as you all have practiced that.
I think you're referring to Pay for Success programs that we have. They've been very beneficial, and it works because what we do is allow those contracts to perform, and then when it does what it says it's going to do, then we pay, and then we use it also as a benchmark going forward. So we learn from those projects as well.
Great, thank you. Those of you, I want to thank you all very much. Madam Ranking Member, if you don't recognize this is called filibustering because I was trying to buy time for somebody to get here. But apparently I failed. That's all I could think of. In any case, it was nice seeing y'all. Thank you, Mr. Chairman. Thank you all very much. Appreciate it.
Thank you. Are you sure the gentleman yields back? Are there any further questions from any members of the subcommittee who have not been recognized? Seeing none, that concludes our hearing for today. I would like to thank each and every one of you for your witness, for your testimony.
No, we'll show you it,
One moment, please. Okay. I ask unanimous consent that the record of today's hearing remain open until such time as our witness have provided answers to any questions that may be submitted to them in writing. Without objection, so ordered. I also ask that unanimous consent that the record remain open for 15 days for any additional comments and information submitted by members or witnesses to be included in the record of today's hearing. Without objection, so ordered. The subcommittee stands adjourned.
I'm sorry if I kept you with the
All right, let's-
Just gonna make sure you have my card, so if you ever get out to North Dakota.
Nice meeting you. Wonderful job.
Yeah, summer's the best time. I mean.